Greetings to the people. You are the people. I'm the people. We are the people. And today, the people are being denied their constitutional rights by the Attorney General of Texas. This denial of constitutional rights is a dangerous precedent and threatens the freedoms of all Americans. The basis of my complaint is a child support issue. I'd like to start off by summarizing the constitutional and federal laws that are the basis of this flagrant denial of my rights, of our rights, the people's rights.
The 14th Amendment of the United States Constitution in Section 1 states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any persons within its jurisdiction the equal protection of the laws. The Title 42, Chapter 7, Subchapter 4, Part D, 666. A law which virtually criminalizes anybody with an order for child support. But this one piece of the law, the only piece where there appears to be some protection in cases like mine, where one of the parties demonstrates that there is good cause not to require immediate income withholding. I have that evidence. I have a prosecution as evidence. Also, it specifies a written agreement is reached between both parties, which provides for an alternative arrangement. I have a written agreement stating that I was current and had no arrearages as of January 17, 2001. I have both these.
Somewhere back in around June of 1999, I was served with divorce papers from my ex-wife. I was ordered to pay child support on temporary orders. A lot of these payments I made directly to my ex-wife. I was naive, wasn't a smart thing to do, but I made cash payments. I even signed over an entire paycheck to her. Back in those days, an entire paycheck was around $1,800. My ex-wife was always complaining that I was late with the payments. So at some point in time, I wrote her a whole series of post-dated checks. And I told her, I said, every 2 weeks when I get paid, you can cash one of these checks. Well, in September of 2000, our divorce was finalized, and it was determined that I should be paying $1,700 a month in child support. Well, at that point in time, I stopped payment on all those post-dated checks that I had written her previously. I was upset. I was angry, okay? So I did not send another payment to her for 6 weeks. At a rate of $1,700 a month, that's a couple of $1,000s easy. And then after 6 weeks, I sent her some money that was short of what I was supposed to pay. All in all, I did accrue a true arrearage of about $3,500.
This panel shows an arrearage on January 21st of 2001 of approximately $7,000. Now, of that $7,000, about $3,000, a little over $3,000 of it were true arrearages. The rest of it comes from the fact that I made cash payments to her, my signed over paycheck, and the post-dated checks that are not credited on my account here. Now, trust me, there is no way that I was going to get by without paying this woman. Okay? She was like like white on rice. when it comes to demanding her monthly payments. She was a spendaholic. I won't go into all that. But at any rate, I did have some arrearages that I was prosecuted for.
Well, that prompted my ex-wife to call me one night and tell me that because I had stopped payment on all these payments, that and haven't sent any money for several weeks, that she was going to rain down a hail of fury the likes of which I had never seen. Okay, well, I started paying what I was supposed to pay, the $1,700 a month. In December of 2000, I came home from work and I found out that the sheriff had been by my house to see me. For what reason, I don't know. I went down to the sheriff's office and was advised that a warrant for extradition had been issued to the state of Virginia, where I lived at the time. For extradition, a warrant for extradition. Turns out that a grand jury in Randall County, Texas, had indicted me on a charge of felony criminal non-support for the arrearages, whatever they were at that time. After bonding out of jail, I retained an extradition attorney. I promptly sent the approximate $3,500 that I was in arrearages and made that payment. And my ex-wife faxed to my extradition attorney a statement stating at that point in time that I was current and had no arrearages. This was on January 17th, 2001. An agreement was reached for me to self-surrender in Texas and avoid the whole extradition process.
This is the letter that my extradition attorney faxed to the district attorney's office in Randall County. He faxed this letter along with the letter from my ex-wife stating that I was current and had no arrearages as of this day, January 17th, 2001.
So, in approximately January 2001, I traveled to Texas, surrendered, spent a night in jail, and was told that, that I was being charged with criminal non-support, a felony, and a hearing was set. In October 2001, I again traveled to Texas to face the charges of criminal non-support in the Randall County Courthouse. I pleaded guilty and was sentenced to probation of 1 year. Upon which the terms of probation, among other things, were to get current and remain current on my child support. After 1 year, I satisfied that period of probation, and the case was disposed with the disposition of restitution made. Okay, at this point in time, around October of 2002, everybody was happy. I made restitution. I paid all outstanding arrearages that were outstanding as of January 2001. I had a signed statement from my ex-wife stating that on approximately January 17th, 2001 that I was current and was not in arrears. I satisfied the terms of probation from the Randall County District Attorney. My felony criminal on-sport case was disposed with a disposition of restitution made, and I thought everything was good. We were square. It was all understood. A number of years later, approximately 3 or 4 years later, came to my attention that the Attorney General of Texas, the agency to collect child support in Texas, the Title 4D agency, still had not credited my account for those arrearages. At which time, I sent them my evidence, the signed document, the letter in my ex-wife's handwriting, signed by her, stating that I was current and had no arrearages as of January 17th, 2001. I sent them information regarding the fact that I was prosecuted for those arrearages and that I satisfied the terms of probation to the district attorney's satisfaction, and my case was disposed of with a restitution made. Now I'd like to review Texas law as it applies to my case.
Texas Family Code, Section 234.0091, the Administrative Review of Child Support Payment Record. Paragraph B states that an obligor or obligee may request that the Title 4D agency investigate an alleged discrepancy between the child support payment record provided by the State Disbursement Unit and the payment records maintained by the obligor or obligee. The obligor or obligee making the request must provide to the Title 4D agency documentation of the alleged discrepancy, including a canceled check or other evidence of a payment or disbursement at issue. In my case, I have a signed statement by my ex-wife, the obligor, stating that I was current and had no arrearages as of January 17, 2001. I have a prosecution as evidence that I satisfied with restitution made. Now, the title, paragraph C says, the Title 40 agency shall respond to request under paragraph B not later than the 20th day after the date the agency receives the request. I've submitted my evidence multiple times, and it's just been totally ignored. The Attorney General of Texas has violated this law by not investigating my evidence and telling me why they won't accept it or accepting it.
Well, eventually they did somewhat acknowledge it and scheduled a hearing to confirm arrearages in Tarrant County, Texas. That's in Fort Worth, Texas. A hearing to confirm arrearages, as well as a hearing to transfer my case from the Fort Worth area to the Amarillo area where my ex-wife now resided. In October 2007, I got on a plane, I flew down to Texas for my hearing to confirm arrearages, and I brought with me my evidence, my letter, my case file for the prosecution. And at that hearing, when I pulled that information out, the lawyer at the Attorney General's office said, no. Held up his hand. Said, no. I can't see that. And you know what? We're not going to do the hearing to confirm arrearages now. We've decided not to. We're just going to do the hearing to transfer your case to Amarillo. And you can do a hearing to confirm arrearages up there. Well, in February 2008, I was notified by the Attorney General's office that they were going to have a hearing to confirm arrearages. And that hearing to confirm arrearages was to take place on March 6th, 2008. On March 3rd, 2008, I called and requested to participate at the hearing by telephone and fax, as it was my right, and was my right under the laws of the state of Texas. I was told at that time by the court clerk that I wouldn't be able to participate in this hearing by telephone and fax because the court did not have a speakerphone.
This denial of my right is based on Texas Statute Section 159.316, Special Rules of Evidence and Procedure, that states that the physical presence of a non-resident party who is an individual in a tribunal of this state is not required for the establishment, enforcement, or modification of a support order or the rendition of a judgment determining parentage, and that documentary evidence transmitted from another state to a tribunal of this state of Texas, by telephone, telecopier, or another means that does not provide an original record may not be excluded from evidence on an objection based on a means of transmission. And in a proceeding under this chapter, a tribunal of this state shall permit a party or witness residing in another state to be deposed or to testify by telephone, audiovisual means, or other electronic means at the designated tribunal or other location in that state. A tribunal of this state shall cooperate with the tribunal of another state and designate an appropriate location for the deposition or testimony. Basically, the Attorney General has broken yet another Texas law. Now, bear in mind that this tribunal, is in front of a judge that's on the Attorney General's payroll.
I asked the clerk to send me that in writing, and she told me that such letter would have to be approved by the judge. 2 days, in the next day or so, I called and asked them about that letter and was told that the judge would not approve such a letter. Now, the day of the hearing, on March the 6th, 2008, I did attempt to exercise my right to a telephone hearing. I faxed my documentation. I faxed a copy of the letter that my ex-wife hand-wrote, signed, and faxed to my extradition attorney in Virginia, stating that I was current and had no arrearages as of January 2001. I faxed the case file for my criminal prosecution, among which the terms were to get current and remain current on child support, and after 1 year on probation was satisfied with a term with a disposition of restitution made. I called the courthouse to participate. They told me at the courthouse that I wasn't there in person and that a default judgment was going to be entered against me. Several days later, I got notice in the mail that the default judgment had indeed been entered, and a bill for $25 for the court costs.
This blatant disregard and usurpment of my rights, my constitutional right to due process, prompted me to file a complaint with the State Commission on Judicial Conduct. I did send a formal complaint, and you can read this complaint here, and you can read the reply by the Commission on Judicial Conduct. Basically, apparently, a judge in one of the Attorney General's kangaroo courts can just do whatever he wants. And the state of Texas apparently condones that behavior. And yet another law that the Attorney General of Texas is in direct violation of is Texas Family Code Section 231.109, attorneys representing the state. It explicitly states that an attorney employed to provide Title 4D services represents the interest of the state and not the interest of any other party. The provision of services by an attorney under this chapter does not create an attorney-client relationship between the attorney and any other party. The agency shall, at the time an application for child support services is made, inform the applicant that neither the Title 4D agency nor any attorney who provides service under this chapter is the applicant's attorney, and that the attorney providing services under this chapter does not provide legal representation to the applicant. More specifically, an attorney employed by the Title 40 agency or as otherwise provided by this chapter may not be appointed or act as an amicus attorney or attorney ad litem for a child or other party.
There's still another law in the books in Texas that bars the Attorney General's office from representing one party or the other, either the custodial parent, I'll put it like this, the person supposed to pay child support and the person who gets to receive the child support. The law in Texas explicitly prohibits the Attorney General's office from representing or being an amicus attorney to either party. I believe that the action of the Attorney General clearly demonstrates that they are clearly acting in the interest of my ex-wife. They have shot me down at every chance just to guarantee, just to maintain the ability to steal my money. Clearly, he's a hostile attorney towards me and a friendly attorney towards my ex-wife, and I believe he's in direct violation of that Texas law. The arrearages that are still on record with the Attorney General's office, which I have clearly demonstrated, have clear and convincing evidence that I paid because of the written agreement by my ex-wife stating that in January 2001 I was current and had no arrearages, and that I was prosecuted and on probation for 1 year and satisfied the terms of probation, which were to remain current with my child support, and after 1 year that case was disposed of with the disposition of restitution made. Now, one thing that the Attorney General cannot do is they cannot prosecute me. They cannot gain another indictment of criminal non-support against me for those arrearages, because I was prosecuted for them once already. But I'm alleging that by sending my employer notice to withhold income, forcing my employer to take money from my account, money that I already paid once, that at this point in time they are stealing from me and violating the law in order to steal this money from me, that is a violation of my right to not be prosecuted twice for the same crime.